आप में से कितने लोग हाउ मेनी ऑफ यू have started understanding CPC? आप में से कितने लोग आप में से कितने लोगों को सीपीसी थोड़ी बहुत समझ में आने लगी कि इट्स वेरी सिंपल जनरल, only thing is that you are required to apply yourself, you have to be in sync with CPC and you have to understand from the very beginning. That's good. Now before I proceed further, let me ask you another question. What general problems you have? जैसे उस दिन वो बघेल भी आया था तो आप बहुत सारे सवाल पूछ रहे थे. You were asking so many questions. Perhaps perhaps I'll be more experienced to answer such questions. And generally we do not have much opportunity to talk on those issues unless and until we dedicate a class. So I give you liberty to ask me general questions, not CPC. I'm not talking of CPC. I'm talking of different things. Let's see, it's beginning of your journey for many of you. And you might be facing certain problems here and there. So I constantly give advice to people that input should not be too much, rather than output should be taken care of. Again, in general, I will suggest you should revise your class notes carefully. You should revise your concepts. Lectures are there in your app. You can listen to them again and again at different speeds at your liberty. So first and foremost advice which I have given you is to concentrate on what you have learnt in the class. And I have also told you, my dear friends, that whenever you write notes, you write on one page and you leave other page empty. Like now your notebook has, let us say, two pages, this is left side, this is right side. In class, you write here. And then you write here your own notes, addition, questions related to this class note, questions basically of mains, and some brief points. Now, apart from this, what you can do, you can write answers. Not of all questions, that is not going to be helpful. You cannot write answers to all questions. Some people start writing answers of all questions. You solve all questions. There will be many topics which will be repeated in your questions. So, don't repeat them. You write answers, one topic, one answer. Now, there can be various topics within a topic. Like we are understanding this parties to the suit. So, you raised a question when parties can be joined together. So, plaintiff, defendant, similar situations, so you can frame one question. Who are necessary party, who are proper party? What is the difference between them? What is the difference between them and write or make it clear by way of example. This is the question, you frame answer. When parties can be added, when substituted, when removed, striking out, addition, substitution, that is what we are discussing right now. Then there can be another question which we will be discussing, we have not discussed. Somebody was asking the question on that, explain order 1, rule 8, I have not explained yet, I will be explaining it. What is representative suit? What is the test of representative suit? When it can be filed? Will it be binding? The decision given in representative suit will be binding on all parties who are having the common interest or community of interest in that subject matter. So you can frame a question. What is the effect of misjoinder or non-joinder of necessary party or proper party? You can frame a question. So you will have to write your answers according to the question, and then there will be applied questions. Is this clear? So at the outset, you should adopt right strategy and approach, otherwise you will be wasting your time. So please be careful and be clear about this fact. We'll start solving question, you can do it. I told you that perhaps from Tuesday or Wednesday, when I'll cover this order 2, rule 2, then we'll be able to clear this, and then we'll go to court, section 9, and that 15 to 20, then we'll start solving. We can do it after order 2 also, no issue. So the moment we complete order 1, order 2, order 3, 4 has nothing, and then order 6 and order 7, then we'll be solving question. So we can start from here also, because initiation of plaint is here. Plaint is ready now, clear, suit is clear. So now we'll go with the suit. So this is suit related questions, suit or plaint related questions. So related to suit or plaint, we'll solve questions in one go. All these questions will be taken care of. So we'll start doing this, I hope, by Tuesday or by Wednesday, because order 2, rule 2 will take some time. We have to go a little slow at the outset. That is the deliberate strategy. Our short notes, so I have already answered Himanshu that you should prepare your answer. You can write brief points, you can see repetition, you can make your own notes, no harm in it. But now that note should be brief points rather than repeating the same thing and writing from books. No. You should not use bookish language, that will be really complicated. You read cases, you pick up some important statements, observations of Honorable Apex Court. Is this clear? That is what we do, Bishalji, question answer format. That is very useful, I hope. Harsvardhan, I said yes, you can start solving men's question, even preliminary question. Preliminary also you can start it, no issue. I'll be dealing with order 1 today. If time permits, we'll go to order 2 also, no issue. So till that point you can do it, no harm in it, because there is Saturday, Sunday, so in between you can start this. Yes, sir. Harsvardhan, it is clear. Aarti, which we are making in CPC will be sufficient for understanding. Yes, please. Yes. Sambhavi, how to manage time? Yes, I'll say that, see, generally your class has around suppose 2 hours 30 minutes. Is this clear? Then I will tell you that you should devote at least 2 hours time for revision. This is must. If you do not do it, then there'll be harm. And then, depending upon the fact that when you are appearing in Judicial Services Examination 2022 or your target is 2023, if your target is 2023, then in that case you can have liberty of reading less and you can wait for some time. Oh, questions have evaporated now. Questions have evaporated now. So rest questions I could not read and they are not here right now. They have evaporated. I don't know why it happens. Technology has certain limitations, no? Questions have evaporated. No issue. So you write down the question. Until Aarti's questions I have seen. So thereafter you can drop your questions further. So I said after class 2 hours revision is must, and I will suggest you read cases. But reading cases is a dangerous exercise in the sense that many people may not be well versed in reading cases and they might consume much time. So read cases after little bit time when you have devoted sufficient time in the class, so that you can be trained in reading cases, because reading cases will consume your lot of time. So it is better that after class and revision, you start solving questions, preliminary and mains. The moment you start doing it, your understanding becomes clear and clear, and these things you have to do. You write questions of mains. If you have certain additional points, you can make your own brief points here. Now, brief points, on notes basically refers to major points, not all points. नहीं बाबू जी, आप जो कह रहे हैं कि ना आप उसको टाइम दीजिए, एचजेएस और आरजेएस के जो सिलेबस हैं उसके अनुसार 3-3 दिन का समय निकालिए और आप उसको पढ़िए. वो तो करना पड़ेगा आपको. टाइम हैज टू बी डिवाइडेड द होल डे. नाउ जस्ट यू आर अटेंडिंग क्लास राइट नाउ, देयर आफ्टर यू रिवाइज, and since morning till afternoon, the time which you have that you can devote for HJS, RJS, but you should have a strict discipline. Those who are appearing in HJS, RJS, they must follow strict discipline. Either you are appearing in HJS or RJS, you must know, like 13 November is this examination, suppose. So you have hardly 20 days time. So 20 days time, now if you have done certain things, so you divide time, 2 days for this, 2 days for this. So you take subjects, you read bare act and solve questions. Bare act and solve questions. Bare act and solve questions. Don't try to read too much. You read bare act and solve questions. You can't do much. You know how to read bare act. If you do not understand bare act, you take class notes and you read it. Don't try to read the material, that you can't do. You have limited time. So preliminary will generally necessitate that you focus on bare acts and solve preliminary questions as much as you can do. You complete one subject at one point of time, like CRPC you have completed. So you answer the questions of CRPC. IPC you have done. So solve the questions of IPC. Is this clear? So that is how it can be done. You read bare act, but not all provisions. I have already told you, my dear friend, for preliminary examination, I have told you to watch my YouTube lecture time and again. How to prepare for a preliminary, I have spoken on that point. How to prepare for preliminary, I have uploaded a lecture on YouTube. You can watch that lecture. That will give you very clear idea. I have said that you have to see the question paper first, and that is how will you come to know what topics are important. And then in this way you will scan the questions and you will come to know the nature of questions. किस तरह से पढ़ना है. मैं सीपीसी क्लास में भी पहले दिन बताया था किस तरह के सवाल आते हैं. जो लोग पहले से क्लास कर रहे हैं दे हैव सम आइडिया. अभी सीपीसी क्लास में मैंने बताया था. सो वो लेक्चर आप करिए, उससे आपको बहुत मदद मिलेंगे. नहीं निशांत जी, आपको क्वेश्चन नहीं समझ पाए. आई एम एबल टू अंडरस्टैंड ईच एंड एवरी सब्जेक्ट, बट ये समझ नहीं आ रहा कि मैं इसके लिए कैसे क्या करूं. किस चीज के लिए? No, I have repeatedly said you are not required to remember all the sections. मैं फिर आपसे यही कहूंगा कि basically you are required to see previous year questions of judicial exam. That will tell you, you just see PYQ of previous year examinations, PYQ of judicial services examination, that will tell you important areas. मैंने इसीलिए कहा ना, बेयर एक्ट को एक बार ध्यान से PYQ के साथ देखोगे तो you will have important areas and accordingly you should study. हर subjects के IPC, CRPC, CPC, the questions will tell you the important areas of exam. If you prepare with this strategy, I don't think that you will fail. But the problem is this, that we do not so you are not required to remember all the sections. You are required to remember important sections, important provisions. वो भी याद नहीं करता. You have to understand skeleton. The moment you understand skeleton, you understand many things. You will have to, now there will be 4 options, so you will be able to pick and choose. So nothing to worry about that. Pulkit. Topper's answer, yes, it is here. Many of the answers are here. So I will let you know that that is not at all an issue. That is not at all an issue. कौन दोनों? ठीक है. And if I have to open, where it will come? कहाँ आएगा ये? मैं ओपन करना चाहूंगा तो. इसको क्लिक करूं? ऑल राइट. सो सबसे पहले तो आपको ये ध्यान देखना है कि भाई आप जो तैयारी कर रहे हो ना, इट कैन नॉट बी डन इन वन डे. इट विल टेक टाइम. 6 months, 1 year, 1.5 years, 2 years. It's a long journey. It is not a short journey. You cannot do anything in one day. If you want to understand CPC, it will require time. It will consume your almost 3 months. Similarly in CRPC, similarly in evidence. So you will have to devote time. अब आप यदि समय नहीं देंगे, if you prepare even food, you know that you are required to devote time, then only food can be prepared well. Otherwise, you will be now not preparing food well and you will be having unhealthy food, which obviously now causes problems for your health. So that is a similar thing here. So you cannot be in hurry. Men's are writing in limited words. ये तो आप समझोगे कोई बड़ी बात नहीं है. It's not a big thing. See, if you understand the concept, then you can minimize the content. If you do not understand, now if I am asked a question today, representative suit पे आप भाई एक short notes लिखो, या or they ask me a question on representative suit. I have told you again and again that, see my dear friends, this is written on page 76 of our Bayer Act. पेज 76. अब देखो रिप्रेजेंटेटिव सूट पे जो भी काम की चीजें हैं वो लगभग 150-200 शब्दों में यहां लिखा है, तो यही आंसर है. सो दैट क्लैरिटी विल कम ऑन एवरी टॉपिक व्हेन यू रीड. द क्लैरिटी विल नॉट कम इन एडवांस, द क्लैरिटी विल कम व्हेन यू विल अंडरस्टैंड द सब्जेक्ट. सो ये क्वेश्चन जो है ना वर्ड लिमिट वाला, इसके लिए आप परेशान ना होइए. It is directly proportional or dependent on your understanding. So if you understand, if you do not understand, then these kind of questions will be coming up in your mind time and again. And many people are affected by such issues. But the moment you start understanding, you start analyzing things very well, then these questions will evaporate. So it will take little bit time. You just wait for it. नहीं, मैंने तो पहले ही कहा बुक से लैंग्वेज नहीं लिखना रूपाली, आपको मैंने पहले ही बताया बुक का लैंग्वेज यूज नहीं करना है. हाउ टू रिवाइज प्रीवियस सब्जेक्ट्स व्हिच वर कंप्लीटेड विद ऑन संडेज एंड सैटरडेज कैन बी यूज्ड फॉर इट. हर्ष गुप्ता, यू कैन डू दिस. क्लास नोट्स में यदि इंपॉर्टेंट पॉइंट आप मार्क करते हो, लिखते हो, एंड देन यू हैव रेड योर बेयर एक्ट वेयर यू हैव मार्क्ड द इंपॉर्टेंट पोर्शंस, सो रिवीजन विल बी वेरी इजी. इफ यू हैव टेकन 10 hours to understand a topic, it may hardly take 1 hour in revising that topic. And similarly, it will be minimized when you read it again and again. नहीं, ये तो बड़ा अजीब सा क्वेश्चन, कैसे क्या करूं. क्या पूछ रहे हैं आप निशांत जी, नहीं समझ में आ रही बात. कैसे क्या करूं, क्या है सवाल ये. क्या पूछना जा रहे हैं, क्लियर ही नहीं हो रहा है. कैसे क्या करूं, अरे कुछ नहीं करना है, क्लास करना है आपको. जो लोग के दिमाग में बहुत प्रश्न आता है, I will request them just attend class easily and effortlessly. Go according to class. Don't think too much. Thinking too much is another problem. जैसे ये क्वेश्चन पूछा ना आपने पुलकित जी, इंपॉर्टेंट टॉपिक्स इन सीपीसी, तो ये ना मैंने आपको बताया ना तरीका, प्रीवियस ईयर क्वेश्चन पेपर विल टेल यू दिस. सो द मोमेंट इफ यू सी प्रीवियस ईयर क्वेश्चंस, इट इज क्लियर what are the important topics. They are the important topics, but generally you have to understand the skeleton of subject. So you cannot pick and choose only कि ये 50 सेक्शन पढ़ लेंगे तो काम हो जाएगा. See, in IPC it is possible, because in IPC major question comes from chapter 4, chapter 16 and 17, and then there are islandic sections here and there which will be asked. But chapter 4, chapter 16 and chapter 17 of IPC is very important, everybody knows. But there are other provisions also which are here and there scattered that you are required to study. But in CPC or CRPC, which is related with procedure, I have already told you in CRPC 154 to 265 is very heart and soul of CRPC. But it does not mean that you will not read chapter 5. It does not mean that you will not read chapter 6. So similarly in CPC, order 1 to 20 is basically the whole process of journey of a civil suit, along with that section 9 to 35B. So this is the journey of suit that you have to understand. But there are then other sections which may be relevant and some orders here and there. Like I have said on the very first occasion that how to keep orders in mind. So that you must have in your mind. If you have missed the class, please see that lecture again. So you will come to know that these are the important areas. On important areas, I have spoken on the first occasion also, but generally speaking in CPC, section 9 to 35B along with order 1 to 20 is very important. Is very important. But there are few and far sections here and there and orders here and there which are also important. But they are in pockets, they are not in totality, they are not in group. But here section 9 to 35B is very important, and obviously this order 1 to 20. This is the skeleton of CPC. बाकी तो मैंने yes, why not? Can we write illustration in men's answer? Yes. Abhinavji, they try to ask different sections because you should know the entire subject. But different sections का मतलब नहीं है कि they ask 100% all sections. ऐसा नहीं है. Yeah, and this cannot be let down as a rule. In CPC, you do not ask all sections of CPC 1 to 158 and all orders of CPC. It never happens. And neither in CRPC, you ask all 484 sections. I have never seen. So Abhinavji, we have to be careful for that. नहीं, केस लॉज आपको इतना याद नहीं करना है ना सली. केस लॉ इतना याद नहीं. यू आर नॉट रिक्वायर्ड टू मेमोराइज केस लॉज. आई हैव सेड इट सेवरल टाइम्स. Why to memorize case laws? Who is going to ask you case law in CRPC, CPC? कितने cases आते हैं? Hardly there are few and far cases which are very important and which appear in exam. Generally see two kind of cases. This is all now related to that lecture which I have uploaded on YouTube. I am telling you time and again, just go and watch. Perhaps you watch it and you do not appreciate what I said there. As far as case laws are concerned, celebrated cases may be important, like in constitution. But all cases, constitution, there are lakhs of cases. So can you memorize all? So this question is not a right question. We are generally now asking a hypothetical question. Why to memorize all? I don't understand it. So only celebrated cases and then recent cases. Recent cases you will come to know if you are in sync with the current news, the current happenings in law, that you must do. All students of law must be in sync with current happenings. But I tell you, 99% will never do it. They have high kind of inertia. They never do it. You tell them 100 times, they will never do it. Nobody is listening news, nobody is looking into recent updates of law unless and until you force them to see it. I have made your task simpler. I have said that you please look into Ambition's Facebook page or Ambition Law Institute community page where we upload recent happenings in law, and we'll try again and again to upload many important cases on other issues. अभी मैं आपको CRPC पे important cases दूंगा, ग्रुप में मैं भेजूंगा आपके which we are updating in our new Bear Act of CRPC. But as you have already taken that, so we will be sending those new cases in your group also through WhatsApp, etc. So we will also be doing it. You should not unnecessarily worry for it. आप अपनी सारी चिंता छोड़ दें. You should not worry at all. You should just follow it. बहुत ज्यादा परेशान नहीं होना आपको. मैं सारे सवालों का जवाब देता हूं. हाउ टू मेमोराइज पे तो मैंने बहुत बार बोला है. इकरा खान, आप देखिए ना, कॉन्स्टिट्यूशन के भी सेक्शन आर्टिकल्स मैंने बताए हैं. सीपीसी का लेक्चर यूट्यूब पे अपलोडेड है इंपॉर्टेंट सेक्शंस का. सीआरपीसी का भी है, आईपीसी का भी है. जस्ट गो एंड वॉच इट. I will try to upload more lectures on different subjects like contract and other things. I will try to do it. Books का language नहीं करना use. Citation writing is not at all important. नेट सही चल रहा है ना? नहीं, मैक्सिम्स भी हम अपने बेयर एक्ट में लिख रहे हैं, आप आईपीसी में भी देखेंगे लिखा है हमने, कॉन्ट्रैक्ट में भी बताया, पार्टनरशिप में भी बताया है, ऑल दिस बेयर एक्ट्स आर अवेलेबल नाउ। देखो, पढ़ने से, जब थोड़ा पढ़ोगे तभी तो आपको पता चलेगा। ऐसे आप मैक्सिम्स के लिए कौन सी किताब देखोगे? ऐसे किताब देखोगे तो इट विल बी बेसिकली ए वेस्टफुल एक्सरसाइज, यू विल बी नाउ डिवोटिंग, इतने सारे मैक्सिम्स हैं, लाखों, उसका क्या करना है हमने? cases लाखों, what will you do with those cases? So why are you worried? You should not worry. That is what I am telling you time and again. You coolly, calmly attend the class. Obviously it will take time. If you have come late, it's not my fault, my dear friends. अब आप आए हैं, हम आपकी मदद करेंगे. See, you study those courses in your LLB at least during 3-year course or 5-year course. So can I complete all those things in few months? If I do it, it will be now injustice to you as well as to the subject. अब ऑर्डर 1 ही हम पढ़ रहे हैं, इतने सारे इश्यूज आपने हाँ, PYQ आप देखो, उसमें है सब कुछ. शशांक जी, श्रेयस दीक्षित, बेटर फॉर प्रीवियस ईयर प्रीलिम्स एंड मेंस क्वेश्चन. तो मैंने आपको बताया, आप एम्बिशन के मेटल में भी मिल जाएगा आपको, उतना भी सॉल्व कर लो तो काफी है, आप उसको भी तो सॉल्व करो. बट PYQ की बुक्स हम लोग भी छापते हैं, एम्बिशन पब्लिकेशन का भी, ऑल इंडिया जुडिशियल सर्विसेज का 25 स्टेट का वो क्वेश्चन पेपर का ग्रुप भी है. हाँ, वैभव खट्टर, आप मान लीजिए आपका प्रिलिमिनरी इज वेरी नियर. नाउ सपोज योर प्रिलिमिनरी इज एट हैंड, विल यू हैव लग्जरी टू रीड इंटायर सब्जेक्ट? So obviously better strategy is, Mr. Khattar, that you must look into previous year question paper and must concentrate on those, because they are important sections. They are important sections. So हाँ शशांक, योर क्वेश्चन, एक आइडियल जुडिशरी प्रिपरेशन के लिए क्या स्ट्रेटेजी? आपको मैंने कहा ना, आप यूट्यूब लेक्चर को थोड़ा देखो, वो डिटेल में मैंने बताया है, हाउ टू प्रिपेयर फॉर प्रिलिमिनरी एंड हाउ टू प्रिपेयर. एक डीजीएस मेंस पे भी मैंने लिखा है, यूट्यूब पे लेक्चर दिया है. सो देर आर 2 यूट्यूब लेक्चर्स. आई विल रिक्वेस्ट यू टू गो थ्रू दैट, बिकॉज दैट विल गिव यू क्लियर आइडिया. लिंक मैं कहूंगा कि वो ग्रुप में आपको भेज देंगे, दे विल सेंड यू लिंक इन द ग्रुप. और क्लास नोट्स तो हम लोग बना ही रहे हैं, तो नोट्स तो हमारे पास लगभग रेडी ही है. आप उसी के ब्रीफ पॉइंट्स बना सकते हो, उसी पे आंसर्स लिख सकते हो. और केस लॉ पे ज्यादा परेशान मत हो, ये अच्छी स्ट्रेटेजी नहीं है, आपको समझ में आएगा धीरे धीरे. सी दिस थिंग्स आर नॉट things which come by experience. I had the similar queries at the outset when I was like you, but now I have understood everything, so I do not have any query in my mind as such. So YouTube lectures on prelims preparation and also how to crack DGS mains. So this will give you idea of mains. DGS mains पे बोला है, but mains का पूरा idea देगा आपको, ये prelims का पूरा idea देगा आपको. So there are 2 lectures on YouTube of Ambition Law Institute. So watch that. That will save your time and my time as well. But see, why I asked you questions today, because I think that many of you are now very concerned about your preparation plan. So don't worry about all those things. This will now evaporate. Himanshu, if you are preparing for RJS, prepare for it. Aage you will have scope of appearing in HJS also, because the exam is very near. Can you provide us any notes on important maxing? We do provide. हम हर सब्जेक्ट में देते हैं, आईपीसी में भी दिया है. Yes, yes, Harshvardhan. I will do everything, Shivangi. I will do everything. We do it. We do it. Don't worry. We do it. If you have not seen my barracks, if you have not seen my material, if you have not seen my class notes, that is why you might have asked this. But I don't think that we have left anything, whatever is relevant for our examination. If it is not relevant, we have not given any irrelevant things in our material and class notes. So it is generally there, yes. How to prepare for translation? ट्रांसलेशन के लिए तो हम लोग पढ़ा रहे हैं आपको, अभी तो आपकी क्लास चल रही है, वहां बताएंगे आपको. इंग्लिश की क्लास चलती है ना, सो देयर विल टीच यू दैट. एंड जीके ऑल्सो वी आर टीचिंग, सो यू अटेंड दैट क्लास रेगुलरली. ओनली रिक्वेस्ट इज attend all classes for 1 year and feel the difference. All these questions which you are asking right now, don't apply your mind too much and don't worry too much. See, if you worry too much, it will spoil your energy and effort. Is this clear? So, अब आपको चिंता नहीं करनी है. You have to be very clear in your mind that you will have all queries settled and answered. So don't worry about them at all. These all questions will evaporate after some time. Attend all classes for a year. Revise your class notes. मैंने आपको कई बार कहा है, जो लोग नहीं पढ़े हैं कोई सब्जेक्ट यहाँ पे, they can look into Ambition's Bare Act. I have said it several times. Or if Ambition's Bare Act is not available on that particular subject, then you can look into other Bare Act. Like IPC Bare Act is coming, everything is written. जैसे in maxims की पूछ रहे हैं ना, we have given the maxims also. One word as well. Recent case, celebrated case, everything is given there. And we have taken care that all questions of preliminary generally answered. I will not claim that I might have succeeded 100% in doing that, but we have generally done it in all subjects. Be it partnership, be it sales of goods, be it specific relief, be it IPC, be it CRPC, be it CPC. We have tried all level best. CPC is the earliest Bare Act. So we will again improve it. How many hours का तो कोई फंडा नहीं है, जितना पढ़ सकते हो उतना पढ़ो. See, your mind should work. If you start reading mechanically for many hours, that is not going to help you. Your mind should be able to receive till the time you read. If your mind is not receiving any idea, why to read? Why to waste time? Rather, it is better to now take some rest. And never read in long stretches. That is not going to help you. दिमाग को अच्छे, have proper sleep, take good food. ये बाहर वाले बाजार वाली चीजें मत खाओ. Fast food should be avoided. Take coffee, apple, all these things are necessary, I tell you. Take fruits. Take care of your health also. Students generally suffer due to health as well. They do not have that much energy to do something with all energy and with all effort. If you are exhausted, how can you work harder? But if your food is proper, sleep is proper, you can work harder and smarter too. You can study for long hours. So be careful, those things are also important. And when you study, you should have calmness. मैं कल की बात बता रहा हूं. Now, there was some kind of insect in my room, and my wife opened the glass window of my room, and I was studying CPC. My house is corner house just adjacent to park. Some children were playing there. So I was constantly being disturbed by the noise. So I looked that side and I found that the door is open. I need concentration for study. I might have requested you also to give me peace in the class so that I can perform better. See, your performance will be better when you study with all calmness, coolness, and with all comfort which is available at that particular point of time in your life. It should be peaceful environment, it should be cool environment, it should be clean environment. अब आप रूम को इतना गंदा बना दियो, क्या आप पढ़ोगे, क्या कंसंट्रेट करोगे? So these all things are going to matter a lot finally, I tell you. And then you can concentrate. If you keep on looking to your mobile phone and keep on listening to music all the time, you can never concentrate, my dear friend. I can't believe this. You need to put best effort in reading. And putting now, you listen to song, but after the break. You take break in between, 30 minutes, 40 minutes, 50 minutes, 60 minutes you have read. You take 10 minutes break. Listen to a song which you like. Do whatever you want to do to relax yourself. But then you sit again, coolly, calmly. If your mind doesn't work well, I tell you, your concentration will be very poor and your reception will be very poor. So output will never be there. You will be wasting your time. So don't go by counting of hours. But if you put more energy, more effort, it is going to produce more fruit. नहीं पढ़िए हिंदी न्यूज़पेपर, ठीक है, अच्छी बात है, हिंदी पढ़ना चाहिए, हिंदी में बहुत सारी चीजें आती है. हाँ, आईपीसी बेयर एक्ट विल बी अवेलेबल वेरी सून. आवर्स तो मैंने अकीब हुसैन बताया ना, जितना पढ़ोगे उतना लाभ है. दिस इज नहीं, हम लोग इंग्लिश में बेयर एक्ट छाप रहे हैं, डिगलॉट नहीं छापते. डिगलॉट इज वेस्ट ऑफ टाइम एंड एनर्जी. डिगलॉट इज वेस्ट. Because you read in Hindi and you read in English also, and that is how you, ये जो suggest करते हैं ना आपको diglot, they don't understand diglot. I have seen diglot. I have taught students in Hindi also, and I'll be giving lectures in Hindi in future as well. So I know diglot is a waste of energy and time. Diglot is not at all useful. Don't do it. You read either Hindi Bear Act or Angrezi Bear Act. Diglot is waste. It is not going to help you anyway. Diglot will not help you. Don't worry about that. So I hope I have settled certain questions in your mind. निधि मनी त्रिपाठी, मैं क्या बताऊंगा. I obviously submit that we have tried our level best. Now CPC is first Bear Act we produce, then now evidence is first. CPC is second, IPC is coming now. So we have put our best effort. We have put our best effort. APO में CPC भी आता है आपके यहाँ? I don't know. हाँ, CRPC also. We have put, now this is earliest Bear Act. Second, this is now I think 6th, 7th, in between many other Bear Acts came. So we have tried to do everything, we have tried to include everything in Evidence Act. Is this clear? And CPC also we have tried to include almost all points. I will say that you please do it. I cannot claim 100% everything, that will be wrong. Nobody is perfect in this world except God. Human being cannot be perfect at all. SRA is also coming. IPC is ready. IPC has gone for publication. It is delayed there. So it will be available by Sunday, that has been told to us. So Monday onwards it will be available to you. IPC Monday onwards. and I think SRA will be available next week. Muslim law also next week. And then we have this Hindu law and contract that is available. We have done our work. Partnership, sales of goods, we have done our job there. Now I will keep on informing you. It is always on the sites also, my dear friend. You can look into there. It is on Flipkart, it is on Amazon, it is on Ambition's website. Those who do not know about where it is available, you go to Ambition's website. You can look into Google search and you can search there. And then you go to Ambition publication, you will find every link there. Ambition publication will be there. Now CRPC second edition is coming because CRPC Bear Act is now out of stock. So it will be coming very soon. Evidence will be coming again. IPC is just coming now. I hope that these Bear Acts will help you a lot in preliminary. It will solve your almost all problem in preliminary and also in mains. Also in mains. Is this clear? Any other question, please? Otherwise, we will move further. I hope you have read that case which is there in your app. I hope you have read that case which is there in your app. सारे क्वेश्चंस आपके देखो भाई लिखने you have asked many questions on answer writing. I must tell you, answer writing is, there is no magic. There is no magic or charm as such. And I do not have magic wand to tell you how answer writing. Answer writing is basically a matter of concept. It's a concept, clarity, and then content presentation. You see, if I am clear about concept, I can present beautiful content of that concept. So you have to be very clear that first conceptual clarity is a necessity. If you write 200 words, but 200 words are not able to exactly tell me what is written there, and if your language is not convincing, clear, intelligent, powerful, can you create effect on the mind of other person? The answer is no. But for this kind of thing, it is not necessary that it should be jaded with legal jargons and it should be full of magical words like Justice Krishna Iyer's writing. It is not so. You can write answers in very simple words, write in your own words as we are writing in class. I am giving you all idea in class. So when you are writing class notes, that is basically preparing you to answer writing. That is basically preparing you to prelims question solving. And that is basically giving you conceptual clarity on the particular point. Because teacher is supposed to teach you everything related to a point. And if anything is missed in the class, then you are there. You can ask me the question or you can ask the concerned teacher the question. टॉपर्स आंसर भी दिखाएंगे. टॉपर्स आंसर का कुछ ऐसा नहीं है भाई, ऐसे मत सोचो कि टॉपर कोई अनोखा चीज, वो भी आप ही की तरह है. जो टॉपर नहीं बने होते ना, आप ही की तरह होते हैं. पहले आप ही की तरह क्वेश्चन पूछते हैं, बाद में टॉपर हो जाते हैं तो उनकी स्ट्रेटेजी आती है, उनके एक इंटरव्यू आते हैं और हम और आप पढ़ते हैं. बट दे आर सिमिलर टू यू, सो डोंट वरी अबाउट दैट. यू विल बी वन ऑफ द टॉपर. इज दिस क्लियर? यू विल बी वन ऑफ द टॉपर. So don't worry about that. You will be one of the topper. Is this clear, my dear friend? So I will provide, don't worry. ओह, इंटरव्यू के लिए आज से तैयारी करना चाहते हो? नहीं, इंटरव्यू की कोई तैयारी नहीं होती. इंटरव्यू इज just a purposive talk. There is no preparation as such. Now interview का जब stage आएगा ना, interview के questionnaires हैं, there will be many interview formats which is available with Ambition. So you should not think of interview right now. In interview you will be asked questions basically what you are studying today. वो CPC के भी सवाल पूछेंगे, CRPC भी पूछेंगे, करंट भी पूछेंगे. तो इंटरव्यू के लिए आपको कोई बहुत तैयारी करने की जरूरत नहीं है. नहीं, कोई डरने की जरूरत नहीं है, आपको डरने की जरूरत नहीं है. डर के आगे जीत है. And I am with you always. So why you are afraid? मैं तुमको ले चलूंगा ना इंटरव्यू में. हाँ ज्ञानेंद्र जी, वो अपडेटेड ही होगा सर. डोंट वरी. So I hope all questions are answered now. Let us begin our journey of order 1. मैं जानबूझ के इतना समय लिया, आपसे पूछा, because I think that you people have certain, but just watch YouTube video on prelims preparation and DJS mains. I'll send you link, don't worry. I will send you link. And you see ambitions barrack, ज़्यादा परेशान मत हो, अभी से परेशान नहीं होना ही. The journey is very now enjoyable. This is joyous journey. Let us enjoy this. Obviously, it will take time. See, if your destination is 1,000 kilometers away and you have only one path to move, reach there, that is roadways, obviously you will take 12 hours or 10 hours or 14 hours to reach there. You cannot reach in 1 minute. You cannot reach in 1 hour. So you will have to devote time. So for that you should be waiting for. You should have patience for that. It cannot happen in one day. So you should not be, if you have come late to me, I can help you now, right now. That is why I advise students, if anybody asks my personal opinion, when one should join coaching, I will tell them in the very beginning. Because what I have done in CPC, tell me, now in reading of CPC, is anybody required to have that basics concept of CPC clear? But generally you will find parents, guardians, now many people, even students saying, पहले LLB कर लो, then judiciary की तैयारी करना. Why? I don't understand it. This is clearly a view which is not substantiated by any reasonable facts, any reasonable opinion. It's not a plausible opinion. It's a misguided opinion. Because you do not understand that. Now, if I start reading or if I start teaching you this IPC, will I not tell you that what is Indian, what is penal, what is code? So I am starting from basics. So where do we need any basic preparation before coming to the class? अभी मेरे को लगता है one of my senior who is based in Patna High Court, he called me that one of his non wants to join coaching. So he said, will you send some book in advance so that she will study before coming to the class? I said, no. Why she will study before coming to the class? I will start from scratch. So even he is not clear. He is my senior. But he is not clear about what coaching institute does. My job is to start from scratch, zero. Is this clear? So you should not worry, you should not be in any doubt, in any confusion, and if you have any, please remove them. Please remove them. Let us be positive, let us be enthusiastic, and we'll start from order 1, rule 10. तो मुझे 5 मिनट का तो आप रेस्ट दे दो, ताकि मैंने आपको बताया था मैं थोड़े ब्रेक पे पढ़ाऊंगा तो ज्यादा अच्छा रहेगा. So please give me 5 minutes rest, 5 to 8 minutes, so that I can also be charged and I can start with order 1, rule 10, rest portions. Is this clear? Is this clear? So अरे मेरा वो छूट गया उधर ही, पेजेस मेरे, केसेस मेरे 3 केसेस थे ना मेरे हाथ में, कहाँ छोड़ के आ गया मैं। ये डाला हुआ है ना ये वाला केस। Now this is the case on your screen, Baluram versus P. Chelathangam and others. Now what is the question in this case? Let me tell you very briefly. This is there in your recorded lecture, this will be there, so you can see it even later on. But let me tell you a question. There is a suit for a specific performance. There is a suit for a specific performance. Is this clear? And in this suit for a specific performance, which has been filed by obviously the plaintiff against the defendant, a person comes and he prays that he should be added as a party. He should be added as a party. Now, who is this person? Basically, the trustees of a trust. Now, see, when you read facts, अब देखो ये सब basic चीजें आपको अनुभव से समझनी पड़ेगी. When you read case law, you read relevant point. You are not required to read irrelevant things. So, I give you very brief facts. There is a trustee. There is a trustee who has entered into an agreement of sale with somebody. Now, beneficiary of the trust comes in the case and says, I want to be joined as the party in this case. Whether you will join that beneficiary where there is suit of specific performance by the purchaser against the trustee. That is the question. So, I hope you understand the question. Now, all those facts which is written here are not important for understanding, they may be important for information. कितने में बेचा, क्या argument था, जैसे 22,000 में बेचा percent, and now beneficiary comes and he says the property should be sold at 50,000% at least. So that is what is the grievance, and he said I should be added as a party. अब आप देखिए यहाँ लिखा है पैरा 5 में ड्यूरिंग पेंडेंसी ऑफ द सूट appellant filed IA interim application in original suit OS number 3 of 2007 in the court of District Judge Kanyakumari at Nagarcoil for being impleaded as defendant, pleading that he will suffer prejudice being beneficiary of the trust if the sale is effected at a throwaway price. So this is what is his contention. So till this point, now you can see this point. What is his prayer? during appellant filed IA in the court and says that I should be impleaded, otherwise I will suffer prejudice being beneficiary of the trust if sale is effected at a throwaway price. So this is the contention. Clear? The application was opposed by plaintiff submitting that beneficiary was a stranger. So he says stranger. So if this is contract. In contract, parties to the contract can file case. Privity of contract, you might be knowing doctrine of privity of contract. And was not a necessary or proper party. This is plaintiff's argument. कि भाई इसको डिपेंडेंट के तौर पे ज्वाइन नहीं करना है. He is not a party to the suit. He is neither necessary nor proper party. Will you join him or not? That is the question. Is this clear? This is the question. यही सवाल है. The trial court accepted the application and held. भाई पढ़ रहे हो, देख रहे हो आप? The trial court accepted the application. It was held that plaintiff was not a stranger to the subject matter of the dispute and was entitled to be pleaded as a party. Now, plaintiff नहीं, appellant, ये गलत लिख दिया. Plaintiff नहीं लिखना था. ये लोग भी पता नहीं कुछ भी लिख देते हैं. This is basically appellant. He is appellant. He is appellant. उससे कोई फर्क नहीं पड़ता. आप ये जानो कि बेनिफिशियरी के बारे में कह रहा. देखो यहीं पे ना विद्यार्थी को केयरफुल, अब उसी में परेशान है. appellant, respondent, petitioner, plaintiff, defendant. You should not worry about this. You just understand a trustee has agreed to sell the property to a person. He has not executed the sale deed. So the party has come for a specific performance and now beneficiary comes in the issue and he said, I am beneficiary. He is selling the property at throwaway price. So my interest is affected. So I should be pleaded as defendant. That's all. So who has come as appellant? This person who is beneficiary. Is this clear? Yes. So this is the issue basically, and now upon this you are required to decide this matter. अब क्वेश्चन समझ में आ गया आपको? आपको यही डिसीजन देना है, क्या करोगे इसमें. अब ट्रायल कोर्ट ने एप्लीकेशन एक्सेप्ट कर लिया, अलाउ कर दिया. ट्रायल कोर्ट अलाउड दिस एंड इम्प्लीडेड हिम एज ए पार्टी. And it was held that he is not a stranger. So what is the reasoning of trial court? Not a stranger. Beneficiary is not a stranger and can be added. Beneficiary is not a stranger and can be added as a party or defendant in the suit. Is this clear? Aggrieved by this decision given by trial court, he preferred a revision petition under Article 227 of Constitution. Before the High Court with the plea that the appellant was not a necessary party. Appellant was not a necessary or proper party and that the order of trial court impleading him as party defendant was erroneous. This is the argument before High Court. High Court ने कह दिया, High Court upheld the plea of plaintiff and dismissed IA filed by the appellant in the suit filed by respondent plaintiff. It was further observed that since suit property is a trust property, the trial court can look into the relevant provision and examine whether the permission of court was required before entering the sale agreement or not. So trial court के order से aggrieved होकर के plaintiff जो है revision petition लगाता है कि appellant ना तो necessary party है ना ही proper party है. So trial court का निर्णय गलत है. Is this clear? हाई कोर्ट ने कह दिया हाँ जी ठीक ही कह रहे हो, हाई कोर्ट अपहेल्ड द प्ली ऑफ प्लेंटिफ एंड डिसमिस्ड IA नंबर फाइल्ड बाय अपेलेंट। हाई कोर्ट ने उल्टा डिसीजन दे दिया, हाई कोर्ट ने कहा वॉट एवर प्लेंटिफ इज आर्ग्यूइंग दैट ही शुड नॉट बी एडेड एज डिफेंडेंट, दैट इज करेक्ट। So trial court allowed him to be pleaded as party, high court disallowed this. Aggrieved by this decision, he reaches to the highest court. अब बहुत सारी बातें बीच में हुई, अब देखो सुप्रीम कोर्ट का डिसीजन आया। आप देखो बाद में इसको ध्यान से पढ़ना। After due consideration of rival submissions, we are High Court heard in interfering with the order of trial court, impleading appellant as a party defendant. So trial court is correct. Admittably, appellant is beneficiary of trust. देखो कैसे आंसर लिखते हैं, यदि क्वेश्चन आ जाएगा तो हम रीजनिंग दे रहे हैं। Appellant is beneficiary of the trust and under provision of Trust Act, the trustee has to act reasonably in exercise of his right of alienation under the terms of the trust. Appellant cannot thus be treated as a stranger. Appellant is not a stranger. No doubt it may be permissible for appellant to file a separate suit. He can file a separate suit, but why? Suggested by successor. But beneficiary could certainly be held to be a proper party. Why? He can file a separate suit, agreed. Appellant cannot thus be treated as a stranger. There is no valid reason to decline his prayer to be impressed as a party to avoid multiplicity. We are avoiding multiplicity of suits, so why not? Order 1, Rule 10(2) enables the court to add a necessary or proper party so as to effectually and completely adjudicate upon and settle all the questions involved in the suit. Even against the wish of, generally see, I have told you even yesterday, plaintiff is master of the suit. You remember that. Dominus litis. But plaintiff is a master of suit does not mean that the plaintiff will have his way all the time. Of course, court is sitting there to do justice. So if court thinks that the matter cannot be effectively and finally decided without impleading a particular party, or his interest is adversely affected, vehemently affected, why he should not be added as a party? Law is obviously meant to do justice. Generally, plaintiff is entitled to have his way. If I do not want to fight against C, I want to fight against B, court cannot compel me to fight against C. But court has got a duty, I will read. Now here also they have read this order 1, rule 10, sub rule 2, I hope so. I will read it for you again. This is how law is read. You are asking questions, I am answering the question. My dear friends, please understand this. आपकी जितने भी सवाल है ना इसी से. Now see here, it is written, court may strike out or add parties. Order 1, rule 10, sub rule 2. अब कहेगा कोई कैसे याद होता है, तो ऐसे ही पढ़ते पढ़ते इतनी बार पढ़ूंगा मैं. Order 1, rule 10, sub rule 2, you will also remember. Adding or subtracting party कहाँ लिखा है, तो order 1, rule 10. So you are not required to make a special effort for memorizing. It will be memorized because you will read it so many times. कहते हैं ना, करत करत अभ्यास हो, जड़मति हो, सुजान रसरी आवत जाते सिल पर परत निशान. So when rope can create a kind of now thing there on the stones, why not we can create impact on our mind so far as memorizing is concerned. So we are wonderful people, we are intelligent enough to do it. You all are wonderfully intelligent, you believe in it. चक दे इंडिया देखा है? नहीं देखा, देखो एक बार. It is not the question that from which school you have come and how many books you have read. It is very important question that how do you read today, and today onwards you must correct yourself. You should not be in hurry. Many people are in hurry. So you should not be in hurry. You should give time. अब मुझे लग रहा है कि order 1 rule 10 में एक केस पढ़ाना है and I just complete the course. No, this is not. You asked me yesterday jointly alternative and this and that. I have brought some examples on that also. Somebody asked me that question towards the end. So it is my duty to clarify everything to the satisfaction of his students. So you be calm, careful and clear about these things, that you have to work sincerely. So I read for you order 1 Rule 10 Sub Rule 2. The court may at any stage of the proceeding, either upon or without the application of either party, even if there is no application of either party, court can do its suo motu. On such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out. Jadi improperly joined, I have told you, bona fide mistake, wrong plaintiff. I have told you yesterday. And that the name of any person who ought to have been joined, whether as plaintiff, defendant, or whose presence before the court may be necessary. Necessary. Necessary comes from necessity. Necessity comes from need. And need is a strong word. So, necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit be added. So, here for necessary and effectual, now decision in the case, this person must be brought in the suit. His interest is adversely impacted. Now, let us read further. The general rule in regard to being dominant letters may choose the person. I have told you just now. He may choose the persons against whom he wishes to and cannot be compelled to sue a person. He does not seek any relief. Consequently, who is not a party right to be implemented against the wishes. But this general rule is subject to provision of Order 1, Rule 2. This you see, this is general. That plaintiff will choose his defendant. But then there is exception. This is how case is to be read. आप केस पढ़ो तो ये सब remark अपने लिखो. That is why I have brought case before you. That is how you will learn how to read cases. Are you able to see this or not? I don't know whether you are able to see this or not, because this is little छोटा करता हूं तो बहुत छोटा हो जाता है. Can you see this or not? Court may strike out or add parties. You have already read Order 1 Rule 10 Sub Rule 2. Clear? Here they explain also necessary party and proper party. Can you see this? Who is necessary party? Who is proper party? We have already discussed, so you can read it again and again. Referring to suit for a specific performance, court in Kasturi held that following persons are parties to the contract who is sought to be enforced, or they are necessary parties. Parties to the contract or legal representative. Transferee is necessary party. A person who has a direct interest in the subject for a specific performance may be pleaded as a proper party on his application. Purchaser of the suit property subsequent to that would be a necessary party. Purchaser is a necessary party. जो जो रेलिवेंट बातें मैं बताऊंगा आपको, बाकी आप पढ़ोगे सारे, पढ़ो, अच्छी बात है. Now, the said sub rule is not about the right of a non-party but about judicial discretion to strike out or add parties at any stage of proceeding. The discretion under the sub rule can be exercised either suo motu or on application of the plaintiff or the defendant or on application of person who is not a party to the suit. So it can be the court can strike out any party who is improperly joined. Not about the right of a non-party, but about the judicial discretion. This is very important, about the judicial discretion to strike out or add party at any stage of the proceeding, either suo motu or on application of the plaintiff or a defendant or application of person who is not a party. This is very, very important. In the present case, appellant could not be held to be a stranger being beneficiary. He is not a stranger. The trial court was justified in impleading him. High Court erred in interfering with the order of. Accordingly, we applied now Justice Thakur and others Kumar Goyal division bench. Two-judge bench is called division bench. Decision of Supreme Court. Is this clear? Is this all right? When you are clear about this, let us come to another case. Plaintiff is dominus litis. The plaintiff who has filed a suit for a specific performance to contract to sell his dominus, he cannot be forced to add parties against whom he doesn't want to fight. Filed a suit for a specific performance, he cannot be forced to add parties against whom he doesn't want to fight, unless it is compulsion of rule of law. A third party or a stranger to a contract cannot be added as to convert a suit of one character into suit of different character. Gurmeet Singh Bhartiya versus Kiran Kant Robinson and others, AIR 2019 Supreme Court this. Position will be different when the plaintiff submits an application to implead the subsequent purchaser as a party and when the plaintiff opposes it. See the new, this is, now आप पढ़ते हैं ना कौन सा केस पढ़ें कितना केस, अब देखो ये नई बात आई 2019 के जजमेंट में, सुप्रीम कोर्ट का निर्णय है, इट इज रेलिवेंट, रिसेंट चीजें हैं तो रेलिवेंट है. इज दिस क्लियर? सो यू शुड नॉट वरी, मैं आपको क्लास में बताऊंगा. And see, you cannot do 100% everything. So be contented with 95%. That is more than enough. You will be a topper. Position will be different when the plaintiff submits an application to implead the subsequent purchaser. This is one. And when the plaintiff opposes such an application for impleadment. Plaintiff submits application, he wants. Plaintiff opposes, he is opposing this. This is two situations. Is this clear? The Supreme Court reiterated plaintiff cannot be forced to add parties against whom it is in a suit filed for a specific performance. See, again, suit for a specific performance. Purchaser who purchased the suit property during pendency of the suit filed an application in the pending suit under Order 1 Rule 10 for impleadment as a defendant in the suit. The case of applicant was that he has purchased the suit property and is a necessary and proper party. He has a direct interest in the suit. Though the trial court allowed the application, the Chhattisgarh High Court set aside the said order of trial court. अब देखो कुछ नहीं है, सपोज करो A has sold property to B. B files suit for Hmm. B file suit for specific performance. Is this clear? A has sold property to B. You are B, I am A. A has sold property to B. So obviously, if I do not give you property, you will file a suit for a specific performance against him, against me. Because there is an agreement between you and me to sell this property. So on that basis of agreement, you will file a case against me. That is what has happened. Now what this A does, now it says the case of that he has purchased a suit property and is an accessory. A sells it to C. Or maybe even B sells the property to C. That doesn't matter. Now the issue is raised that can C be made party, the party of subsequent sale? B is first party. A ने किसको बेचा प्रॉपर्टी? B को, और फिर किसको बेचा? C को भी. तो B जब स्पेसिफिक परफॉर्मेंस का वाद ला रहा है, नाउ C कम्स एंड ही सेज दैट मुझे भी पार्टी बनाओ. प्रश्न यही है, क्या आप C को पार्टी बनाओगे? नहीं बनाओगे? द इश्यू रेज्ड इन द अपील before apex court was whether the plaintiff can be compelled to implead a person in the suit for against his wish, and more particularly with respect to person against whom no relief has been claimed by him. He doesn't claim any relief against C. B does not claim any relief against C. B is claiming relief only against A. Is this clear? B तो A से कह रहा है तुम पर स्पेसिफिक परफॉर्मेंस करो, वो C से कुछ नहीं कह रहा. He doesn't ask anything, he doesn't involve C, he is just concerned with A and he says, you please perform the part. You please sell the property. मेरे को दो भाई, तुमने कहा था मुझे प्रॉपर्टी मिलेगी, मुझे दो. You have to give me property, that is what is the suit of B against A. B does not have any case against C. The issue raised in the appeal was this. The bench comprising Justice D.Y. Chandrachud and Justice M.R. Shah noted that in Kasturi, apex court held that question of jurisdiction is to invoke order 1 rule 2 not made a party in the suit by the plaintiff shall not arise unless party proposed to be added has direct and legal interest in the controversy. We further held that two tests are to be satisfied for determining the question who is an accessory party. अब क्या है टेस्ट वो भी देख लेते हैं. There must be a right to some relief against such party in respect of controversies involved in the proceeding. And the effective decree can be passed, no effective decree can be passed in absence of such party. Ab, considering these two tests, the first observation are made by this court considering the principle that the plaintiff is dominus litis and cannot be forced to add party against whom he does not want to fight unless there is compulsion of rule of law. Therefore, considering the decision of this court in the case of Kasturi, the appellant cannot be impleaded as a defendant in the suit filed by original plaintiff for a specific performance between the original plaintiffs and original defendant number 1, and in a suit for a specific performance of the contract to which appellant is not a party and that too against the wish of the plaintiff. The plaintiffs cannot be forced to add party against whom he does not want to fight. If he does so, in that case it will be at the risk of plaintiffs. Two other judgments relied by appellants were Robin Ramji Bhai Patel versus Anandi Bhai Rama and Sri Swastik Developers versus Saket. In this regard, the bench said, in both the aforesaid cases, it was plaintiff who submitted an application to implead the third parties, who claimed title under the vendor of the plaintiff. Position will be different when the plaintiff submits an application to implead the subsequent purchaser as a party and when the plaintiff opposes such an application for impleadment. This is the distinguishing feature in the aforesaid two decisions and in the decision of Kasturi. So just try to understand, my dear friend, it's very, very important. What it says, plaintiff who submitted an application to implead the subsequent purchaser who claimed the title under vendor of the plaintiff. Position will be different when the plaintiff submits application to implead the subsequent purchaser as a party and when the plaintiff opposes such an application. So if he wants to implead, we have no issue. We will implead him. But if he is opposing here, and that is what will go against him, this is distinguishing feature in the first decision. And this will go against him. Suppose in this case you just understand this point. You should not worry at all. Question मैं फिर से बताता हूं आपको. Question क्या है? That A has agreed to sell his property to B, did not execute sale agreement. So now B has come to the court and he is seeking relief of specific performance. He says to A that you please perform the contract, give me the property. Is this clear? In the meantime, C gets interest in the property, he becomes subsequent purchaser. Fact does not say from whom he purchased, so we are not going into that question, that is irrelevant also. He might have purchased it from A, he might have got better price. Now B has filed suit against A. B has filed suit against A for a specific performance and he has no claim against C. He does not look to C. Now he comes to know that C is the subsequent purchaser. Now it is upon B to add him or not to add him. So there can be two situations where B wants to implead him, add him, and where B does not want to add him. So court says if B wants to implead him as a party, then there is no issue. We will add him as a party. Order 1, Rule 10, Sub Rule 2 says that. Because he is interested party, his interest is also affected like beneficiary in that case. So why not he should be added? But when plaintiff opposes this and plaintiff has no right to relief against C, B does not have any right to relief against C. So the twin test also is not satisfied. जो लिखा है यहाँ, there must be a right to some relief against such party. So whether B has any right or relief against C, relief against C, no. And no effective decree can be passed in the absence of such party. So this test is not satisfied. He does not have any right to relief against C. B को कोई C से मतलब नहीं है. This is privity of contract. Privity of contract में you file a case against the party to the contract, not against the third party. Not against the third party. Obviously, it will be duty of A to either specifically perform this contract or to refund the money, or to compensate B in some way. This will be duty of A. Now, B could have added C as a party to obtain the property, but he doesn't want to do that. He is dominus litis, he is master of the suit. So, we are not going to compel him for that matter. But now you must be very clear, because you will find cases like this and where it will be written that in such situations, basically in situation of specific performance, this subsequent purchaser in many cases is considered a necessary party. I think there are decisions to this effect in many cases. But then this 2019 decision makes a clarity on the point that these are two different situations, when plaintiff wants to implead him and when plaintiff opposes him. So when plaintiff opposes him, let it be so, because he does not have any right or relief against him. But if plaintiff wants to implead him for betterment of his interest, for betterment of protection of his interest, because he has to obtain the property, then he should be impleaded. So this is what is the point which we are required to understand. When plaintiff impleads him or plaintiff wants impleadment of that person, and when plaintiff opposes. When plaintiff wants impleadment of that person, should be done. If he doesn't want, we should not do it. That is a distinguishing feature. I think in other decision also such things are written. I read it at other places also. I read many decisions, but all of them I cannot quote. last page, it is written here. Gurmeet Singh Bhartiya versus Kiran Kant Robinson. Is this clear, my dear friend? ये दोनों केस आपको समझ में आया नहीं आया? देखो यही तो लिखा है, इसी केस में तो पढ़ रहा था। ये जो केस है, द केस ऑफ दिस इज बालूराम वर्सेस पी चेलाथंगम, बालूराम वर्सेस पी चेलाथंगम. In this case, Justice A.K. Goyal, which was decided in year 2014, there very clearly they said court concluded that purchaser of suit property subsequent to the suit agreement would be a necessary party. इसी में तो पैरा 19 में पढ़ा था, वही मैं कहा मैं और भी डिसीजंस पढ़े थे. Purchaser of the suit property subsequent to the suit agreement would be a necessary party as he would be affected if he had purchased it with or without notice of the contract. But this is 2014 judgment and this is Gurmeet Singh's 2019 judgment. So 2019 judgment gives better clarity that it will depend upon the fact whether plaintiff wants his impleadment or where plaintiff opposes his impleadment. Is this clear? (2019) decision. I hope you will remember that point which I have said. Now there is another very interesting case. भाई ये केस कहाँ है? This one, this is case of Pankaj Bhai Ramesh Bhai Jalavadia versus Jetha Bhai Kala Bhai Jalavadia. See, my dear friends, if you do not understand this thing, that in law there is dynamism and courts will keep on giving decisions, and these recent decisions are very important for your exam, and that is why it is necessary to read these cases. Pankaj Bhai, Ramesh Bhai, Jalavadia versus Jetha Bhai, Bhai, not Bhai, Jetha Bhai, Kala Bhai, Jalavadia. Deceased. Through legal representative and others. This is AIR 2018 Supreme Court 490. Best method of studying is read cases. बुक्स पढ़ने से आप कभी भी लॉ के न्यूएंसेस को, क्योंकि इसमें डिस्कशन है, इसमें डिस्कशन है, ये डिस्कशन आपको समझना पड़ेगा तभी आपको मजा आएगा एंड लॉ के न्यूएंसेस को समझोगे. आई रेड दैट डिसीजन बिफोर यू, अरिबानंदम. सी द लैंग्वेज, दैट इज हाउ यू लर्न लॉ बेटर. बुक्स हैव लिमिटेशन. Whatever books you read, they have limitation. That is why many universities follows this case-based method, but they do not follow to the fullest extent, and they are not able to tell the student that how case has to be studied. That is another demerit. They will give you case study material and they will leave it to your destiny. They will never train you how to use it properly. But in this class, you must train yourself how to do it properly. अब देखो ये इतने pages में लिखा है, मतलब I read it. Now this is page number 1, then this is page number 2, this is page number 3, page number 4, page number 5, page number 6 कहा. अब ये पेज नंबर, ये 6 पेजेज पढ़ने में एक स्टूडेंट को he will devote or she will devote 1 hour. I also devoted 40-45 minutes. So it's a rigorous task. It's time consuming. So people will avoid it, evade it. But we should not. This is how. And what is the question? इस केस में सवाल क्या है मैं आपको बता दूं, बहुत ब्रीफली सवाल बताता हूं. आई टेल यू वेरी ब्रीफली व्हाट इज द बेसिक इशू इन दिस केस. पंकज भाई, रमेश भाई, जलावाडिया वर्सेस जेठा भाई, काला भाई. अब ये नाम मुझे याद नहीं रहेगा कभी, एंड आई विल नेवर ट्राई टू रिमेंबर दिस. I can remember in a recent case, Supreme Court said that. I should know law. If I am required to quote before a court as a lawyer, then I will find the citation and I will read it. I will show it to the court. But it is not so necessary in examination that you will write exactly AIR 2018 Supreme Court 490. This is not the requirement of your examination. I have made it clear number of times. No citation. If you remember anything like this, Salim Bar कब का केस है, if you remember, Kailash versus Nanku is case of what time, you remember, you write down. If you do not remember, you write down only Salim Bar Association case, Kailash versus Nanku case. Why to write citation? I don't know. Teacher will be happy. Nobody is interested in making you a clerk who can remember all figures, facts. No. Understanding and concept is required. If I keep on memorizing that who was plaintiff in this case, who was respondent, who is appellant, then I will be wasting my enormous energy. And it is all waste. And I tell you, maximum students have problem due to this reason that they waste their energy. That is why I asked you your questions today. Many people will think that I wasted your time, but I know what I did. So you must understand that you should not be involved in now futile things. अब याद कर रहे हो इसी को बैठ के, अरे यार वो कौन सा केस था सर ने आज बताया था, पंकज भाई, रमेश भाई, जलावाडिया, जेठा भाई, काला भाई, जलावाडिया. अब वो भी परेशान है कि जेठा भाई, काला भाई पहले था कि पंकज भाई, रमेश भाई पहले था. एपेलेंट कौन है, रिस्पोंडेंट कौन है. अब क्यों कर रहे हो ये सब? दिस इज ऑल वेस्टफुल एक्सरसाइज. So I tell you in this case what happens. एक person है, जो भी है ABCD, we are not concerned with that. He files a case against another, and that person was dead. But he filed a case. Now this fact was known in between when the suit proceeding was continuing. Now question arose, can he request for impediment of his legal representative and successors? So his lawyer might have suggested that order 22 is there, you just use it. So he went under order 22 rule 4 and he requested for bringing them as party. Order 22 rule 4. Order 22 rule 4. Order 22 rule 4. Can you see order 22 rule 4? Where one of the two or more dependent dies and right to sue does not survive against the court on an application made in that behalf shall cause the legal representative of the deceased dependent to be made a party. Dies when Dies when? So it says that this provision will be invoked when the person dies during the proceedings. If the death has occurred beforehand, then this rule will not apply. So he filed his petition or his prayer under Order 22 Rule 4, which he should not have done. So his prayer is rejected under Order 22 Rule 4 on the ground that the death has not occurred during proceeding, death has occurred before this proceeding was initiated. So Order 22 Rule 4 will not apply. Now he wants it to be done under this Order 1 Rule 10. Order 1 Rule 10. Now this is the basic question here. You can look into this. See here, the application is not allowed, no order has to cost. First he filed, is it in your app or not? Is it in your this or not? I don't know. It is here or not? ये इसमें है कि नहीं इसमें? इसमें है? कहाँ है? ये कौन सा केस है? पंकज भाई कहीं लिखा है इसमें? No bar for filing application under Order 1 Rule 10 even when that filed under Order 22 Rule 4 is dismissed as not maintainable. So court says there is no bar for filing application. There is no bar for filing application under Order 1 Rule 10 There is no bar for filing application under Order 1 Rule 10 even when the application under Order 22 Rule 4 was dismissed as not maintainable. The legal heirs of the deceased person in such a matter can be added in the array of the parties under Order 1 Rule 10 read with Section 151. Subject to the plea of limitation as contemplated under Order 7 Rule 6 of the Code and Section 21 of the Limitation Act to be decided during the course of trial. Question of limitation you cannot decide beforehand because it is mixed question of law and fact. Counting has to be done. So that is what is decided during the course of trial. So, but he can be admitted. He can only wrong he committed was that fact that he was not filing this application in proper provision. That is only mistake which he has committed. See this judgment of Mohan M. Santana Gowder. Mohan M. Santana Gowder. I will tell you to mark relevant provisions here and there which can be used. I will draw your attention towards this para 4. Para 4. I want to tell you this para 4, just see para 4. Can you see para 4? This is trial court as well as high court are justified in rejecting application for impediment of the disease filed under, since the application filed by appellant initially under order 22 rule 4 was dismissed and second application was for the very same purpose. This is what is relevant. This can be a question. It was for the very same purpose. The courts below were justified in rejecting the application preferred under order 1 rule 10. If further submits that application preferred under this to include the legal representative is not maintainable since the appellant has not questioned the earlier order rejecting the application filed under this and therefore the said order was attained finality and binds the applicant. The appellant cannot be allowed to file another application for the same relief by invoking different provisions. This is the question. Now this is the question. Is it correct that he is seeking the same relief by quoting a different provision of law of the same court? Earlier he filed the application under order 22 rule 4 which was rejected on the ground, this is written on the left side, on the ground that order 22 rule 4 can be invoked only when the death has occurred during pendency of the proceeding. If death of the defendant has occurred beforehand, before proceedings, before filing of the suit, then this order 22 rule 4 cannot be invoked. Now you tell me that whether such kind of technical interpretation of law will result into substantial justice, that is my question. I have told you, my dear friend, happy are those nations where law is not treated as mathematics. Law has to serve a purpose. Law has to serve a purpose. It has an end. It has an aim. So law has to serve a purpose. We are sitting here for purpose, not for performance of a mechanical thing. If I sit in class and I am not able to communicate, I am not able to convince you, it is just wastage of your time and my time. It should serve a purpose. I should be able to communicate to you. So law has a purpose to do justice. Law has a purpose to do justice. So this should not be the fact that on the ground of technicality, on the ground of technical nicety, you will reject a petition or prayer and then you will not allow that petition or prayer to come through another provision because of the reason that there is some situation like res judicata that you are asking for the same relief, so I am not going to allow this. This is the argument which has been taken in this case. But is it proper argument? That is my question, that is my query. I hope you will agree. You will not only agree, you will absolutely agree that the essence of law and the very heart and soul of law is to do substantial justice in a case. Now see here, it says bare reading of order 22 makes it clear that applied only in case where death of, para number 6. See para number 6, applied only in case where the death of one of the several defendants during the, if one of the defendants expired prior to the filing, the legal representative defendant cannot be brought on record in the suit under order. This is the point. Then order 10, rule 1, rule 2. पूछते ना आप आंसर कैसे लिखना, देखो ना order 10, rule 1. अब आप आंसर राइटिंग में एग्जैक्ट लैंग्वेज तो लिख नहीं पाओगे, तो आप अपनी भाषा में लिखोगे. Is this clear? Order 1, rule 10. You are again and again telling that what is order 1, rule 10. So there are too many repetitions also in the judgment. Para number 8. Where is para number 8? Merely because the earlier application under Order 22, Rule 4 was dismissed as not maintainable, it will not prohibit the plaintiff from filing another application which is maintainable in law. The only course open to appellant in the law is to file an application for impediment to bring on record the legal representative addresses under Order 1, Rule 10. So, this is the only course open to appellant to the person concerned, and he will not allow this. This is justice. Hence, order passed by trial court on the application filed under Order 22 Rule 4 will not act as res judicata. Will not act as res judicata. This is the only course open. And if you deprive him of even this course, भाई मेरे को सिर्फ एक रास्ता है और वो भी रास्ता बंद कर दो, ये न्याय है? आपने कह दिया कि भाई डेथ हो गया है पहले, इसलिए ड्यूरिंग प्रोसीडिंग इसलिए ऑर्डर 22 रूल 4 में आप नहीं कर पाओगे, रिप्रेजेंटेटिव नहीं ला पाओगे, डेथ हैज अकर्ड बिफोर, एंड ऑर्डर 22 रूल 4 अप्लाइड ओनली व्हेन द डेथ अकर्स ड्यूरिंग प्रोसीडिंग. So you have shut my door there. Now you say that no, you cannot bring this through another provision because this matter is already decided. So on one end you are taking technical ground to disallow my right, and on another end you are saying that you cannot use other provision to come to the same point because of res judicata or something like that. Is it acceptable? The answer is no. The rules should not be so technical. Now let us see para 14, which is very, very important. Rest of them are not so important. Para 14. In the matter and in hand, under Order 22 is not maintainable at an earlier point of time in our considered opinion, it's to mention that trial court at the point of time itself could have. अब देखो कोर्ट कह रहा है, I said Justice Krishna here, quoting Justice Krishna here, that activist judge is an answer to frivolous litigation. Similarly, I will say that activist judge is the only hope or one of the hope to get substantial justice. The judge should have himself done it. That you have brought an application under Order 22 Rule 4 which is not proper. Rather you amend it and you bring it under this Order 1 Rule 10 and I will give you relief. So it says the trial court at that point of time itself could have treated the said application filed under no. Not only you bring it, he said treat it, you should have treated it like this in order to do justice between the parties. This is what the court is saying. So the court should have itself done that Order 22 Rule 4 application will be treated as Order 1 Rule 10 application and I am going to grant this relief. So court should not be technical. Court should be tool to justice. And procedural law is handmaid to justice. It is a mistress, not a master. You should not interpret law in such a way that it obstructs the path of justice. So it says, Order 1 Rule 10 of the code at the initial stage by the advocate for the plaintiff. Merely because of non-mentioning of the correct provision by the plaintiff's advocate, party should not be made to suffer. It is now well settled that a mere wrong mention of the provision in the application would not prohibit a party to litigation from getting justice. Ultimately the courts are meant to do justice, not to decide the application based on technicality. अब देखो यही सब तुम्हें बातें लॉ को लिखने में मदद करेगी, आंसर लिखने में. This is what is answer writing. This paragraph you read carefully. You are asking me question on answer writing. I am answering your question on answer writing, my dear friends. This is how better answers can be written if you read better language. The provision under Order 1 2 speaks about judicial discretion. I have just read. See, you repeat the same thing. to strike out or add parties at any stage of the suit. Reason and fair play. It says reason and fair play. And not according to whims and caprice. The expression to settle all questions involved in Order 1, Rule 10(2) is susceptible to liberal, wide interpretation, so as to educate all the questions pertaining to the subject matter thereof. Parliament in its wisdom, while framing this rule, must be held to have thought that all material questions common to the parties to the suit and to third parties should be tried once for all. This is what is my purpose. Read para 14 carefully. The court is clothed with the power to secure the aforesaid result with the judicious discretion to add parties, including third party. In a suit seeking cancellation of sale deed, as mentioned, a person who has purchased the property and whose rights are likely to be affected to the judgment in the necessary party. If such purchaser has expired, his legal representative are necessary parties. In the matter of hand, since the purchaser of the suit property has expired prior to the filing of suit, his legal representative ought to have been added while presenting the plaint. As such, impediment was not admitted at the time of the filing of the plaint in view of the fact that the plaintiff did not know about the death. He cannot be non-suited merely because of his ignorance of said fact. To do justice between the parties and all legal representative of the suit property. So his ignorance should not be made a ground for his punishment. In many cases, people may not be so sincere. Then read further. As mentioned, Supra, it is only if a defendant dies during the pendency of the suit that the provision of Order 22, Rule 4 can be. Since one of the defendant, that is, has expired prior to the filing, there is no legal impediment in impleading the legal representative of the deceased defendant under Order 1, Rule 10 of CPC. For simple reason that the plaintiff in any case could have been suited a suit against the legal representative on the date he moved an application for making them parties, subject of course to the law of limitation. See here it says, hyper-technical approach, which has been adopted by the courts here. So court allowed that. Court allowed that. Is this clear? Is this clear? तो आप पढ़ना पैरा 15. Having regard to the totality of narration made supra, there is no bar for filing application under Order 1, Rule 10, even when application under Order 22, Rule 4 has been dismissed as not maintainable. Legal error of the deceased in such matter can be added in array of parties. Is this clear? Appeal is allowed. Trial court is directed to implead legal representative of defendant number 7 and bring them on record. So you read this judgment of Jalavadia versus Jalavadia. Is this clear? ये सब नहीं करेंगे ना तो फिर आप पढ़ेंगे नहीं सही ढंग से. So please do it for God's sake. Please do it for God's sake. Is this clear? Pankaj Jalavadia. Now coming to another issue, you asked me certain thing on this jointly and alternative, that was the query and concern. So I have brought few more examples for you, which will perhaps clarify the point further, which we discussed yesterday in Order 1, Rule 1 and Order 1, Rule 3. Order 1, Rule 1 deals with, somebody was asking me today, Order 1, Rule 7. उनको क्या क्वेश्चन है इसमें? क्लास को थोड़ा सा ध्यान से सुनेंगे। मैंने आपको कल भी बताया था ऑर्डर 1 रूल 7 व्हेन देयर इज डाउट। मैंने एमसीडी डीडीए का एक एग्जांपल भी दिया। आई गिव एग्जांपल ऑफ एमसीडी डीडीए। आई एम नॉट श्योर that this building comes under control of MCD or DD. I am in doubt. So will I not file case against both? The court will see who is the rightful person or rightful authority in such situation, whether it is MCD or DDA. No? Is this clear? कल बताया था। और रूल 8 अभी हम पढ़ेंगे रिप्रेजेंटेटिव सूट के बारे में। When two or more were jointly entitled to same relief, पढ़ा ना हमने यहाँ, जैसे पढ़ा ना, any right to relief in respect of arising out of same act or transaction or series of act or transaction is alleged to exist in such person whether jointly, severally or in alternative. And rule 3 में भी पढ़ा, all persons may be joined in one suit as defendant where any right to relief in respect of arising out of the same act or transaction or series of act is alleged to exist against such person, whether jointly, severally or in alternative. Right to relief. So jointly entitled to same relief. So speak example like when two or more persons are jointly entitled to same relief in respect of a transaction, they must all join as plaintiff one suit. And similarly, if we have something against some persons jointly, then they will be joined as plaintiff, defendant. Now, if A, B, C are joint owners of property, they must be joined as plaintiff in a suit to recover the property. अब A, B, C तीनों joint owner हैं, आप ही बताओ, छोटे छोटे example हैं, and they want recovery of their property. They are joint owners. So whether they are jointly interested in relief or not, they must all be joined as plaintiff in a suit to recover the property. Jointly entitled to same relief. So they are jointly entitled to same relief. And the relief is the relief of recovery of property. So they are jointly entitled to same relief. In a suit to recover joint family property, all the members of the joint family must, as a general rule, be joined as plaintiffs. ठीक है? All family members of joint family in a suit to recover joint family property. So they are seeking joint relief. Example 1, example 2, joint relief. Joint relief. Similarly, there are many other examples. In a suit to recover the trust properties, all trustees to recover trust property. All trustees have joint relief. All trustees. And question arose. Now, similarly, see, there are many examples. ये सब jointly entitled है relief के लिए. Then there is another example. Oh. How it came again. If a person is dead and there are many executors of his property, so for proper execution of his property, all executors should join hand or not? The answer is yes, they are jointly entitled to relief. Now, if any one of them does not consent to join as plaintiff, then what is the course? See, there is a question. Suppose there are many trustees and they are all entitled to recover trust property and they are all custodian of trust property, all family members have to claim joint family property. If one of them does not join, he does not pay court fees, he does not bear expenses, many issues may arise, or he may be obstructing party, he doesn't join in that. अब आप क्या करेंगे? जैसे आप पार्टीशन सूट ही लाए and all sharers have to be there and one of them does not join and he rather obstructs it. So what will you do? He doesn't want to join. So you will implead him in other way. You will ask the court to implead him as defendant if he is obstructing. So the court says, now you may frame a question. If in such a situation all plaintiff does not join, when there is joint relief, all plaintiff does not join where there is joint relief, then if in such a situation all plaintiff does not join where there is joint relief, then in that case if in such a situation all the plaintiff does not join when there is joint relief, then in that case, that plaintiff, if in a situation you write here not all plaintiff, now one or the other plaintiff does not join. Does not join where there is joint relief, then in that case he can be impleaded as defendant. Then we can bring him in that way. Court, I'll ask the court to make him defendant in that situation. He does not consent, but the suit should not be dismissed merely because he has joined as defendant without being first called upon to join as plaintiff. Yes. So if he does not consent, if he does not join as plaintiff, then we will make him defendant in the case. But suppose if in a situation, if he has not been asked to join as plaintiff, rather directly he has been asked to join as defendant, or he has been served notice or served summons to join as defendant, can the suit be dismissed on this ground? The answer is no. Even if he has not been asked to join as plaintiff and he has been impleaded as defendant, there may be an issue between one party and the other party. There may be issue between two sharers, two co-partners, two partners. So he might have been pleaded as defendant, so that is not at all an issue. It is all to be seen in the decision of the court. So this is not an issue that he has not been asked to be pleaded as plaintiff first, rather he was pleaded as defendant in the first go. So that is not an issue at all. Is this clear? So ये कोई मसला नहीं है और इस आधार पर आप सूट को डिसमिस नहीं कर सकते. तो ये तो बात था. अब देखिए एक सिचुएशन ऐसा भी है कि आपने जॉइंटली तो समझ लिया, अब नॉट जॉइंट इंटरेस्ट क्या है, तो इसके लिए भी एक एग्जाम्पल का यूज करते हैं. एक बड़ा अच्छा एग्जाम्पल मिला मुझे, एंड दिस इज एग्जाम्पल ऑफ मुल्ला. ही सेज हिंदू डाइज लिविंग ए विडो. अच्छा है, दिस इज हाउ यू कैन अंडरस्टैंड बेटर. हिंदू डाइज लिविंग widow, adopted son, and a separate brother. My brother has already separated. Is this clear? A dispute arises between widow and adopted son on the one hand and brother on the other. And there is a dispute between widow and adopted son on one hand and separate brother on another hand. There is a dispute versus. Is this clear? Regarding some property. In the dispute, widow and adopted son allege that the land forms part of the estate of deceased. Brother on the other hand alleges that land belongs to him. If widow does not dispute adoption, a suit may be brought by her and adopted son as co-plaintiff against the brother to recover the property from him as the plaintiffs are jointly interested. So, they say that land forms part of estate संपत्ति को कह रहे हैं डिसीज, जो मर गया, मृत, जिसको मृत कहते हैं आप. Land forms part of estate of deceased. And separate brother, he says that land belongs to him. Land belongs to him. So this is the dispute. This is the brother's contention that land belongs to me, and they say that land forms part of estate of deceased. And widow does not question adopted son's adoption. Widow, इसको ऊपर लिखते हैं, widow does not question adoption. So there is no dispute between widow and adopted son. They are on one hand and separate brother on another hand. So their interest is joint interest. Their interest is joint interest because she does not raise objection on adoption. If she raises objection on adoption, then there will be dispute between widow and son also. So they cannot be said to be jointly interested. Is this clear? So here there is joint interest. But suppose in the same case, widow objects or raises objection on adoption, and she has issue with the separate brother also. So in this case, can widow and son be said to be jointly interested? Tell me. Can widow and son be said to be jointly interested? The answer is first no. So in this case, if widow and son join as plaintiff, then it will be a case of misjoinder. कल भी मैंने आपको कहा था, if you join somebody against rule 1 or rule 3 of order 1, then this is case of misjoinder. Order 1 rule 1 is for plaintiff's joinder and order 1 rule 3 is for defendant's joinder. So if you join them as per the rule, if there is compliance of order 1 rule 1 and order 1 rule 3, then you can join them as plaintiff or defendant. So that is proper joinder. But if you join them against order 1 rule 1 or against order 1 rule 3, then it is misjoinder. So is it a case of misjoinder or not? Yes, because they are not jointly interested in the relief. There is no joint interest. There is no joint interest. There is no joint interest. Now, then you asked me question on alternative relief also. So let me explain a little bit about that as well in this situation itself. Now, widow prays to decide adoption first, to decide adoption, and if adoption is proved, if adoption is not proved. This is alternative. So she claims that if adoption, her prayer is that if adoption is proved, she says, If adoption is proved, the property may be delivered to, then property may be delivered to, देखो आप कह रहे थे अल्टरनेटिव, may be delivered to adopted son. If adoption is not proved, then property may be delivered to widow. So here we are claiming alternative relief. Here it is question of alternative relief. There is no joint interest, no joint relief. It is alternative relief. Is this clear? But is this clear? Is this clear? You change the fact situation. Suppose widow does not object adoption, rather the brother objects adoption. Then brother can bring a suit, or rather then widow and son can bring the suit in that case as co-plaintiffs, because they are jointly interested. They are not disputing. They are not disputing. Lady, the widow is not disputing adoption. Suppose I am taking a third situation. Widow is not disputing adoption. So widow and adopted son are well and good, and they file a suit for this property and say that the brother is not entitled, we are entitled. But brother says that now son is not validly adopted, and he raised objection on adoption. So in that case, what the adopted son and widow can do, they can raise question of relief like this, that if adoption is proved, the property should be delivered to son. If adoption is not proved, the property should be delivered to widow, and they can join as plaintiff, because the objection is not raised by widow, objection is raised by brother. So brother will be defendant and these two will be co-plaintiffs. Is this clear? And they can take this plea of alternative relief, that if adoption is proved, property should be delivered to the adopted son. If adoption is not proved, property should be delivered to the widow. Is this clear? तो अल्टरनेटिव का थोड़ा बहुत मीनिंग तो आप समझ ही गए होंगे, और जॉइंट का तो देखो बहुत जगह यूज करते हैं, जॉइंट टॉट फीचर, जॉइंट टॉट फीचर सुना ही होगा आपने, जॉइंट एंड सेवरल लाइबिलिटी, जॉइंट टॉट फीचर, वन जॉइंटली ना। अब एक अल्टरनेटिव रिलीफ का आप और एक एग्जांपल बताते हैं आप, अल्टरनेटिव रिलीफ। सेवरल का तो जॉइंट एंड सेवरल, जॉइंट टॉट फीचर have joint and several liability. Alternative. A executes a lease. A executes a lease to be for 2 years. ठीक है, कितने दिन का लीज है? 2 साल का. After 1 year, he sells property to C. He sells property to C. C demands रेंट फॉर सेकेंड ईयर। सी ने सेकेंड ईयर के लिए रेंट डिमांड किया क्योंकि सी की प्रॉपर्टी हो गई अब। इज दिस क्लियर? ए ने पहले लीज किसको दिया था? बी को। कितने दिन के? 2 years। फ्रॉम मेनी ईयर्स? 2 years। And after 1 year he sells the property to C. So now C is rightful owner. So obviously C will demand rent for second year. There is nothing wrong. Is this clear? C दूसरे साल के लिए C मांगेगा पैसा। Now B alleges that I have made payment for 2 years in advance. I have made payment for 2 years to A in advance. अब देखो बड़ा इंटरेस्टिंग है। अब जो सी का प्रेयर होगा क्या करेगा वो? तो सी अल्टरनेटिव रिलीफ क्लेम करेगा। कैसे? तो देखिए, समझिए बात को। Now she will file alternative relief. Alternative relief. She will file alternative relief. क्या relief? C may sue A and B, praying for a decree against A if it is found that B paid the rent to A as alleged, or in the alternative against B if it is found that B did not pay the rent. So C may sue A and B praying for decree against A praying for decree against A if it be found that B paid rent to A. If it be found that B paid the rent to A. Is this clear? Or in alternative, against B, or in alternative against B, if it be found that B did not pay rent to A. If he has paid the rent, A is entitled to pay this to C. And if he has not paid the rent, B is entitled to. So there is alternative relief. He will file suit against A and B both. And he will pray that if B has paid rent to A, then A should pay me. If B has not paid rent to A, then B should pay me. So this is what is alternative relief. You should not have any iota of doubt. Obviously, your learning will be better when you will see more and more cases and you will come across more and more example. But this class is meant to give you clarity at the outset. भाई साहब महान है आप, लेकिन मान गया आपको। बोथ ए एंड बी आर नेसेसरी, उन्हीं के खिलाफ रिलीफ मांग रहे हो तो नेसेसरी नहीं है तो क्या है वो। इसलिए कहते हैं ना, कुछ भी सवाल नहीं पूछना है, कुछ भी पूछ करके ना आप भ्रमित कर देंगे दूसरों को भी। जब हम रिलीफ उसी के खिलाफ मांग रहे हैं, उसी के खिलाफ केसी कर रहे हैं तो नेसेसरी नहीं है तो क्या है भाई। He has filed suit against A and B, both ना, दोनों के खिलाफ सूट लाया है। कैसी बात कह रहे हो भाई, ये तो नेसेसरी नहीं है, उसी के खिलाफ तो रिलीफ है। कैन वी से का क्या मतलब है? इट इज सो। नाउ लेट अस रीड ऑर्डर 1 रूल 8। एक इसमें टर्म हम लोग यूज करते हैं ट्रांसपोजिशन भी। अब आप पर रूल 10 पे कुछ कुछ यहां केस भी लिखा है, पढ़िएगा। मैंने तो आपको और केस बता दिए। ट्रांसपोजिशन का मतलब है प्लेंटिव को डिफेंडेंट बना दे, डिफेंडेंट को प्लेंटिव बना दे, दैट इज व्हाट इज कॉल्ड ट्रांसपोजिशन। प्लेंटिव को डिफेंडेंट बना दिया तो ट्रांसपोजिशन हो गया। सिमिलरली डिफेंडेंट को प्लेंटिव बना दो तो ट्रांसपोजिशन हो गया। Order 1 Rule 8. Please look into Order 1 Rule 8, and I have written beautiful short notes on Order 1 Rule 8 for your purpose. Just a minute, hold on. I am just coming. 2 minutes, 2 minutes, 2 minutes. I am just coming. Look into Order 1 Rule 8.